ineffective assistance of counsel. What is it, and how can a person fight a conviction if they've had ineffective assistance of counsel? I'm a criminal appeals lawyer, and that means that I help people appeal after they have been convicted, after they have been sentenced. And in many cases, they have received ineffective assistance of counsel. What it really means in a nutshell is the lawyer was bad. The lawyer was so bad that the lawyer fell below the minimum standards that are required for a criminal lawyer. So let me share with you what the two-step process is to determining if someone can benefit if they've been convicted after having ineffective assistance of counsel. So first, you have to show that you received ineffective assistance of counsel. And the second thing you have to show is that it had a negative outcome. You were prejudiced by the outcome. So the first step is showing you received ineffective assistance of counsel. The U.S. Supreme Court has said everyone has a right to a lawyer under the Sixth Amendment, and that right means that you have a right to a lawyer who meets minimum standards of effectiveness. Now that standard can vary by community, by what the standards are for criminal defense lawyers in any given community, but essentially it's an analysis of what the lawyer did, what the lawyer did not do, and what a lawyer of reasonable competence would have done, should have done in similar circumstances. So the first step is showing that the lawyer fell below those minimum standards. Maybe, for example, the lawyer said, if you plead guilty, you're going to get a 5-year sentence. I promise you, just say yes to whatever the judge asks you, you'll get a 5-year sentence. And then you're in prison, you realize you have a 25-year sentence. That would be ineffective assistance of counsel, for the lawyer to tell you the wrong thing and induce some plea deal. Another example might be if you have a trial and the lawyer is doing such a bad job in the trial that it's essentially like you didn't have a lawyer at all. Some famous examples: lawyers who were intoxicated during the trial, lawyers who fell asleep during crucial portions of the trial, lawyers who did not use crucial information that any reasonable lawyer would have used, evidence of third-party guilt that was right in front of them they could have presented, etc. So it's a case-by-case analysis to see whether there's ineffective assistance of counsel. But the second step is very important, which is to show prejudice. That's what the law requires. You have to show that the lawyer not only was so bad they fell below minimum standards, but what they did had an impact on the outcome. Obviously, if the jury is giving their verdict and they say the person is guilty, and at that moment the lawyer were to fall asleep and not hear what the verdict is, well, that wouldn't have an impact on the outcome. Obviously, this happened after the jury verdict. So there are many other instances where a lawyer's deficiency might have no impact on the outcome. So that is the second step, whether there was prejudice shown, whether because a lawyer's ineffective assistance of counsel, the person received conviction when they wouldn't have received a conviction, or they received a more severe penalty that they would not have received if the lawyer met minimum standards. So that's essentially the two-pronged test. Was the lawyer below minimum standards, and was prejudice shown? This is just the tip of the iceberg. I hope this has been helpful. If you have any follow-up questions, you're welcome to call me. I'd be happy to speak with you or have another lawyer at my firm speak with you. Thank you. Take care.